Hello, I'm Dominic Walker, JMW's Inside Man. My guest is Anamitri Mukhopadhyay. Anamitri is a solicitor within JMW's Intellectual Property Department. So, Anamitri, we've heard so much about Ed Sheeran's case recently. It's captured lots of people's imagination and is probably much more high profile than any other copyright case might be. What exactly has Ed been accused of? What's happened here?
Yeah, so like you said, this case is very sensational. I think we often forget with litigious cases as well, they are sensational, people's emotions are at play. And in this one, Ed Sheeran, he was labelled as a magpie who allegedly borrows songs from other artists. And, Sheeran's lawyers have said this case is quite traumatizing for him. 2 million worth of royalties were suspended by PRS. So just to give a bit of a background on this case actually dates back to 2018 when Ed Sheeran and other co-authors of the very famous song that I'm pretty sure most people know about, Shape of You, also one of the other two co-authors, in case people are interested, Johnny McDade from Snow Patrol and the music producer Steve Matt. So all three of them were accused of plagiarizing Sam Chokri, who goes by the name Sammy Switch's 2015 song, Oh Why. So Sammy's quite a famous grime artist, and I'm sure many people are familiar with him and his song. So the allegation is actually in relation to a particular hook. So the OI hook in Ed Sheeran's Shape of You, which Mr. Chokri claims is strikingly similar to his refrain, Oh Why, in his song. And Ed Sheeran and the other co-authors, they commenced proceedings in the High Court to seek a declaration from the court that they had not infringed Mr. Chokri's copyright, where it was actually decided that Ed Sheeran had not in fact copied Sammy Chokri's song.
And you say not copied the song. What exactly did the court decide? How did it do this?
So before I kind of talk about the judgment on a general basis, I thought it might be useful for our viewers to know the law surrounding copyright infringement. So the first thing is, to qualify under copyright infringement, the song or any work has to be original, and only original material can qualify under copyright protection. The second thing to note is that the author or the creator of the song, they have the first right as copyright holders. And as copyright holders, they have exclusive right to copy, adapt, or just work with the work, so to speak, in any way possible. Also, at this point, I will add in one thing, because we get a lot of inquiries from clients asking, how do you register copyright? There is no requirement to register copyright. Copyright actually occurs as soon as the work is created. So this is quite different from trademark or design right, where we would usually advise client subject to our research and review of matters, to protect and register the trademark and design right, but there is absolutely no requirement to do that with copyright. So copyright in a musical work may be infringed if the work is copied or produced in a substantial form. So substantial, to clarify, is qualitative rather than quantitative. And the last thing I'll add on this is that the world of legal burden usually rests with the person alleging infringement. In cases of conscious copying, the evidential burden actually shifts to the alleged infringer if there's any proof of access. So just for the context of this case, Mr. Chokri would have to prove that Ed Sheeran had actually listened to his song. Otherwise, the similarities are purely coincidental. So now I'll go a bit into the judgment. So like I said, the High Court ruled that Ed Sheeran had actually not plagiarized the OI hook in the song at all. So the judge actually said that there was neither deliberate nor subconscious copying of the phrase. There were obviously similarities with the songs. I've listened to it and there is some similarity with the hook, but I think on the whole, there are important differences, which is what the judge also said, because the moods of the songs are very different. With regards to access, which is something that I mentioned earlier, the judge found that Chokri's team had actually failed to establish that Mr. Sheeran had access to Mr. Chokri's song. The judge rejected the defendant's contention that Ed Sheeran had access to the song from various sources, such as music blogs. The defendants at the time, they were publicising the song and Mr. Chokri to make him more popular in the UK, or from Mr. Sheeran's acquaintances who might have told him about the song. Also quite interestingly, I found the judge actually considered that Ed Sheeran had actually given credit to other artists in instances where he might have taken, bits of their song. So because of that, the judge also found in his favour. So yeah, all good result for Ed Sheeran.
Yeah. Anna Mitri, I mean, it's always difficult, I suppose, these sorts of cases. There's a limited number of notes that you can use in a song.
Yes.
I know you specialise in music and the entertainment industry in general. How can you help, those who work in those industries, musicians, etc.?
So Dominic, the IP team has extensive experience handling with, lots of IP cases in various industries, the entertainment industry being one of them. And I've actually handled a trademark infringement case involving tribute bands, which was really interesting. So I've also got some experience on this matter.
Excellent, Anna Mitri. Thank you very much. Lovely to speak to you. And I'll enjoy listening to Ed Sheeran a bit later on as well. If you'd like to speak to Anna Mitri, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.